Welcome. Welcome to our next edition of the Cerini Nonprofit Connection. We have with us here today David Mahoney, partner at SilvermanAcampora. Welcome, David.
Thank you, Ken.
David's here to discuss a topic. I think I get more questions about this topic than any other topic from my clients. You're going to talk a little bit about employment law issues and maybe helping some of the organizations that are listening on some of the key issues that they're dealing with. So again, thanks for coming, and hopefully we can shed a whole lot of light. But before we get started, why don't you talk a little bit about what you do and what your firm does with the nonprofit sector?
Sure. So I'm a partner at SilvermanAcampora. It's a full-service business law firm in Jericho, right here on Long Island. The firm can help businesses and business owners in virtually every aspect of running a business, all the way from the idea of an entrepreneur or someone who's looking to start a business, and every step of the way, whether it deals with employee issues, real estate, dealing with government contracts. We really run the gamut of every aspect of a business's life.
Okay, and same with the nonprofit sector.
And the nonprofit sector falls right within our wheelhouse. We have several not-for-profit clients.
And from your expertise within the firm, you really deal mostly with the employment law issues?
So I'm a member of the employment law group and the litigation group.
Okay.
So I would say I would spend roughly 70% of my time dealing directly with business owners and with HR professionals, trying to help them set up policies and procedures that avoid litigation.
Okay.
And of course, there's always times when either we're not brought in to a situation until litigation's already present, or we're in the process of trying to fix a mistake or omission that happened before we were involved. And sometimes that's when either litigation or some other form of alternative dispute resolution is required.
What do you see as some of the biggest issues that you have to face when you're kind of working with your clients in terms of some of the biggest problems that they're running into?
I think that one of the largest things we're dealing with right now is wage and hour compliance.
Okay.
Making sure that our clients, whether they're for-profit businesses or nonprofit businesses, that they're properly classifying their employees and that they're properly paying their employees. There's still a perception out there that paying people on a salary basis is both easier for an employer and in some cases an employee. Many employers and employees look at being paid on a salary basis as a level of status within a company.
Okay.
And, not being paid by the hour, but being paid a set salary every week conveys a trust in that employee and conveys a certain level of respect that the employer has for the employee. The problem that we run into is that trust, respect, deference is not viewed by the Department of Labor as a sufficient justification to pay somebody a salary and treat them as though they're exempt from both federal and New York State overtime laws.
Okay. So I know that when an employee gets hired, you have to look at them and determine whether they're an exempt or a non-exempt employee. Can you talk a little bit about what's the difference between an exempt and non-exempt employee? And you mentioned that as one of the issues that you run across. Why is it an issue with respect to employment?
Sure. So let's just start from the default that you can pay any employee an hourly rate of pay for every hour that they work. When you do that, you have to understand that if they work more than 40 hours in a week, you're going to have to pay them time and a half. So if somebody makes $15 an hour, once they work 40 hours in any given work week, every hour after that, you have to pay them $22.75 or $22.50.
Okay.
Okay.
And is that on a work week, or is that also on a work day perspective?
It's just on a work week perspective. Okay. So if somebody works 8.5 hours in any given day, you don't have to pay them overtime for that extra half hour under New York law. But if they work more than 40 hours in a work week,
And it doesn't matter how you pay them. If you pay somebody every 2 weeks or pay them twice a month, it's still looked at on a work week
it's
basis.
still looked at on a work week basis.
Okay.
So one of the things that we tell clients up front is make sure that you know what your work week is, and make sure that your employees know what your work week is.
Okay.
So once we start from the premise that everybody can be paid as an hourly employee, there are certain classifications of employees that under New York law can be exempt from overtime. And we call those employees either exempt employees or salaried employees.
Okay.
In order for an employer to pay one of its employees as an exempt or salaried employee, you have to take a look both at the relationship between the employer and the employee.
Okay.
And you also have to take a look at exactly what that employee does for the company.
Okay.
When you're talking about the relationship, we're really talking about how much money you're going to pay them.
Okay.
So there's a minimum salary threshold for administrative and executive exemptions under New York state law.
Which is?
So it varies based on where that person is working within New York State.
Okay.
If you're working in a large company in New York City, and large is relatively small, it just means, more than 10 employees, that employee has to receive a set weekly salary of at least $975 a week.
Okay. And outside of New York City?
Outside of New York City, it can vary all the way down to $780 a week once you get outside the New York metropolitan region.
Okay. And is that a bright line? That is, if they get over that, they're exempt. If they're under that, they're not exempt?
It's the first threshold.
Okay.
Okay. So when somebody tells me that they have an exempt employee, that the first question is, how much are you paying this person? And I'll often hear, I pay them $1,000 a week. I'm fine. Well, let's hold off on the conclusion that you're fine. What does this employee do for you? And there's a few enumerated exemptions under New York state law. You have an administrative exemption, you have an executive exemption, you have a professional exemption, and you have a computer specialist exemption. The minimum salary threshold relates to both the administrative and executive exemptions. I don't want to get too granular on what goes into those, but for an administrative exemption, you're really looking at somebody who doesn't perform manual labor on a regular basis and generally works in an office and makes decisions that affect the company, and that person exercises independent judgment, independent decision making, and basically has control over some aspect of the company's business.
Okay, so when we talk about someone who's making judgments on behalf of the company, how large do those judgments have to be? So if someone is approving time records, if someone is approving purchases, if someone has the ability to make purchasing decisions for a company, is that enough to put them over that threshold?
It certainly can be in the context of what else they do with the company. Those are the types of criteria that we look for. Essentially, if somebody has decision-making authority about how a business treats its employees, how it spends its money, how it collects its money, and just the overall business venture, then those are the types of that's the type of autonomy and the type of power that we're looking for when trying to decide if somebody is in fact properly classified as exempt from New York State's overtime laws.
Okay.
There are other types of exemptions, like a professional exemption and a computer specialist exemption, that one, don't require a minimum salary under New York state law, but still require a lower minimum salary under federal law. But what we're really looking for with those exemptions is what that person does for the company. Is it some type of specialized work, generally requiring an advanced degree or somebody who exercises a significant amount of independent judgment, critical thinking, a specialist in their industry.
So would
So
that be like a teacher or a therapist or a?
exactly. So typically you think of doctors,
Mhm.
you think of nurses, you think of attorneys, you think of certified public
I
accountants,
thought you were going to leave that one out. Most people don't think of those.
uh, teachers, in certain types of therapists and behavioral specialists. We work with several not-for-profit companies where that's the interaction that we have with them. They're employing early childhood educators and behavioral therapists. Often they have to deal with either New York State, federal government, or local governments to obtain grants or some type of
Okay.
um, some type of fees that either come from the state or from local school districts.
Okay.
Um, so I mentioned the distinction or the professional exemption that people don't necessarily have to have that increased New York minimum wage or minimum salary, because some of those professionals are paid on a fee for service basis,
Okay.
or essentially paid for performing certain tasks.
And how does that come into play with respect to this whole?
So with certain professional exemption employees, they may only work for a not-for-profit or any company for that matter for, say, a portion of the work week.
Mhm.
And they may not justify paying them on a salaried basis, but you use them on a regular basis. Each one of the tasks that they perform has a certain individuality to it, has a uniqueness, and requires um, their their personal skill in judgment. So it's allowable under federal law and not discouraged under state law to pay those people for the performance of a specific task.
Okay.
So let's take a therapist, for example. A therapist can be an employee of a not-for-profit and can be paid on a per case basis.
Okay.
In that circumstance, the company may have certain clients that it assigns to a therapist, and the therapist may be told, look, for every session that you perform, that's a discrete task, and we're going to pay you $100 for a 1-hour session, so to speak. That person's going to be paid $100 for that 1-hour session, with the understanding that there's going to be other soft time above and beyond that 1-hour session that they're going to have to expend in order to complete the task.
Okay.
And that if the person's properly classified, that time is not independently compensable.
Okay.
To determine whether or not the person is being paid enough, we just back into what that person's effective salary would be if the person was performing that task for 40 hours a week. Anybody who's essentially making $40,000 or more generally is making enough money to qualify for the professional exemption on a fee basis.
So it's kind of a prorated salary based on time worked.
Essentially, yes.
Okay. And I assume with those types of individuals, that should all be spelled out in whatever sort of agreement you have with them.
Yeah, I like to see, whenever you're dealing with how somebody's paid, New York State has certain forms that are required to be given to employees so that they understand the method of payment and what they're going to be paid, either on a salary basis or on an hourly basis. What I tell clients is to make sure that they're being completely transparent with their employees about how they're being paid, when they're being paid, and what they're being paid. If you do that, you're generally satisfying federal and state regulations, and more importantly, you're fostering an open you're fostering open communication with your employees, and I think you're avoiding unnecessary problems that arise when somebody doesn't understand the terms and conditions of their employment.
How do you typically advise your clients to communicate those terms and salary and everything else, and also whether an employee is exempt and non-exempt? Do you normally look for agreements, offer letters, salary notices? What's the best way in your opinion?
So I think that whatever fosters open communication between the employer and the employee ends up being in the best interest of all parties. One thing we're often asked by clients is, do I need an employment contract with the person I'm about to hire? And typically my answer is probably not.
Okay.
Unless you're looking to lock this person up for a set period of time and you want to make sure they don't leave to go somewhere else. An employment contract often binds the employer as much as it does the employee. What I mean by that is New York State is an at-will employment state.
Mm-hmm.
What at-will employment means that the employer or the employee can terminate that relationship at any point for any reason whatsoever, as long as it's not a discriminatory reason. So what I prefer to see in the vast majority of circumstances is an offer letter. It's typically a 1-page, maybe a 2-page letter. It's very simple. It's from the company to the prospective employee that lays out what the company expects from the employee once they start working for the company, and lays out what the employee can expect from the company in return.
Okay.
Offer letters should always include a statement laying forth the at-will employment arrangement, making sure that the employee understands in clear, concise language that I like to see actually in bold font. It says, nothing in this letter is intended to promise employment for a certain amount of time. This is an at-will employment arrangement. You are free to move on if you decide to, and the company's free to terminate your employment if it sees fit.
One of the things when we read a lot of these offer letters and stuff, we were talking before about exempt versus non-exempt. Mm-hmm. A lot of them that we see don't mention whether an employee is exempt or non-exempt, and I'm assuming that's something that really should be in the offer letter.
If the person is going to be treated as an exempt employee, it absolutely should be in the offer letter. Again, open communication to me is one of the keys of maintaining a good relationship between an employer and employee. It should be clearly spelled out, and the employee should understand, if I'm going to be salaried, that means my typical work week may be 9 to 5. If I work 9 to 7 or 9 to 8 every night for an entire week because we need to get something done, I would like that offer letter to make clear that I shouldn't be expecting overtime for that extra work. It should also be clear to the employee that if it's a slow week and I only work from 9 to 4:30 Monday through Thursday, and Friday I work 9 to 2, I'm still entitled to that same weekly salary. And that's the sort of give and take, one of the gives and takes of employing somebody on a salaried basis.
One of the things I was actually going to bring up, because we see it happen all the time. We go in, we're looking at doing a payroll test or something, and we see somebody showed up 15 minutes late and see them docked on their salary. You want to talk a little bit about how what an employer can do with an exempt employee with respect to if they show up late or if they're having issues, and how that interplays with maybe their vacation time and things like that.
So the law requires a minimum salary test and a job description test for deciding whether or not somebody should be exempt. Although it's not in the law, one of the things I tell clients is there should also be a do you trust this person test, because there is a certain amount of faith that the employer has to put in an employee that they're going to pay a regular salary. With a salaried individual, if somebody does any work in the course of a day, they're entitled to get paid for that day.
So does
if-
that even include like if they answer an email at home?
Yes, under New York state law, yes.
Okay.
So what we try and tell employers is, if you don't think that this person is going to commit themselves to the position, this may not be somebody that you want to pay a salary to. Because remember, once you're paying somebody a salary rather than an hourly rate, you're no longer paying them for how long they work on something. You're paying them for what they do without regard to how long it takes. So employers need to have a certain amount of faith in salaried employees not to take advantage of that status. They're always willing to take the benefit of having somebody who works and grinds and, burns the midnight oil and pay them the salary. But they always have to understand that if someone's really efficient, or somebody even isn't as diligent as you'd want them to be, if they're working less than 40 hours a week, you're still paying them a salary. Now, you can still have paid time off, and you can still tell salaried employees, look, if you're going to be out for a day, take some paid time off, whether it's vacation, whether it's sick time, and you can still have paid time off banks for salaried employees. But one of the issues that we often see, especially near the end of summer, is an exempt employee has, say, 3 weeks of vacation for a year. They took a week at February break, took the kids to Disney. They have 2 weeks left for the year. And over the course of the summer, they take a day here, they take a day there. They go down to the shore for a week, and suddenly they're out of paid time off. But they also have already told you, well, I'm going to take my kid to school on the first day of school. And you have employers who want to dock those employees and say, no, they already burned all their paid time off. I want them here. And if they're not here, I don't want to pay them. Well, this is the deal that you made when you hired somebody to be a salaried employee. You can't go tit for tat with them on certain things. That being said, you pay the person for the day, especially if that person has email on their phone or takes phone calls from a cell phone. Any work they're doing that day, you need to compensate them for the day. When we run into situations where salaried employees really start to abuse that trust, really start to abuse that relationship, we caution employers to not dock them pay, but to go through the process of actually counseling those employees, to put them on performance improvement plans, to explain to the employee that we think you're letting the company down. We don't think you're living up to the other end of the bargain. And if the behavior continues, if the company feels like the person is either incapable or unwilling to understand the company's concerns and to change their behavior accordingly, at that point you start to think about whether or not you really want this person to be an employee and in a position of trust.
So if I've got a situation where an employee has been showing up late consistently, and maybe it's 15 minutes a day for a 2-week period of time, can I apply that against their sick time or their vacation time, or no? All I can do is counsel and communicate if they have sick time or vacation time left.
Are we still talking about exempt
employees? Yeah.
But my recommendation is that they don't.
Okay.
Practically speaking, if that's your concern, and if you voice that concern to the employee, and if the employee refuses to change their behavior, or for some reason isn't capable of changing that behavior, that needs to lead to a larger discussion about whether or not this person is the right person for that position. But the first question I'm going to ask the employer in that scenario is, I understand you expect them to be there at 9. They usually don't show up until 9:15. Is that having a negative impact on your business? Is it inhibiting their ability to get their job done?
Right.
Is it holding up other employees' ability to get their job done? Is it negatively impacting the productivity of your office? And if it's not, you may have a circumstance where you just have somebody who can get everything done that needs to get done and doesn't have to stick to the same schedule that you've
Established,
envisioned in your head.
or maybe just rotate the time
Yeah.
so that they work from 9:15 to
Right.
5:15 instead of 5. I think we have a question. So, see what the audience wants to know about.
If someone is a new exempt employee and is still on probation and therefore not yet entitled to use time, are they still entitled to pay if they don't work a day?
They come up with tougher questions than I do.
Okay, so the legal answer to that question, let's start with the idea of probation.
And by the way, you understand that voice came from God, right? So
Let's start with the idea of probation. Because New York is an at-will employment state, to a certain extent, employees are always on probation. And I like to avoid using a phrase like probationary employee, because once that probation period ends, have you now created the expectation in the employee that their job is safe?
they're permanent, yeah.
Okay. But getting back to the specific question that was asked, there are different ways that employers can offer paid time off to their employees. Some offer it all up front at the beginning of a year. Some require employees to accrue that time over the course of a year. If someone is using unaccrued paid time off and you are confident that they didn't do any work on that day, and typically that means they don't have access to the tools necessary to perform their job functions outside of the office, an argument can be made that you don't have to pay them. Now, the caution I'm going to give anyone who's looking to do that is speak to your employment attorney before you dock them the pay. Because we want to be confident that they didn't do any work on that day. So that's the way we look at it from a legal perspective. From a practical perspective, this person may be relatively new to the organization. This person may have come across a circumstance that requires them to be out of the office for an entire day before they've accrued that paid time off. But looking at that relationship from 10,000 feet, what is the company's overall goal with this employee?
Yeah, it comes down to tone. Yeah, what tone are you trying to create?
Are you looking to get the most out of that employee every single day until you burn them out? Or do you look at this new employee that you hired on a salary basis as a productive, meaningful, important member of your team? And if you're looking at this person as someone you are looking forward to a long relationship with, that you see them being a member of your team for years to come, my advice is going to be practically, don't be petty. Don't be penny wise and pound foolish. Don't potentially get that relationship off on the wrong foot. Now, if you see it happening over and over again, then the employer, the manager, the owner can start to develop an opinion that maybe this person isn't in it for the right reasons. Maybe this person isn't in it for the long haul. But I ask people to take a look at the circumstances under which somebody comes to an employer and says, I know I don't have the time. I need to take this day off. Generally, people who are new at a job are always trying to put their best foot forward. And typically that person doesn't want to come and make that request. they don't want to take that day off. Usually there's a very good reason, one that they can't avoid. And, you know, even in our own firm, we've had young attorneys who don't have time built up, and they may need to take off a day, 2 days, an entire week. And the way we look at it is the person may not have the time built up, but this is somebody we hired because we see them being an important member of our team for years and years to come. If they get paid for a couple days that they didn't work, that's an investment in this relationship.
You're building goodwill.
Yeah.
Yeah, I think that's important. So, to change the subject a little, I mean, we were talking about, you know, employees and all of the issues that you have to work with from an exempt, non-exempt perspective. I think we see a lot of times that nonprofits would just rather say, hey, wait a minute, let's just not call them employees. Let's just treat them as outside contractors, because it's so much easier to deal with an outside contractor than it is to deal with an employee. But obviously we know that you can't just call someone an outside contractor because you don't want to deal with the employment law issues.
Right.
So let's talk a little bit about, you know, what constitutes or when can I treat someone as an outside contractor, and when do I have to treat them as an employee?
Okay. Great question. Let's start with the simple premise that independent contractors are in business for themselves. If someone is truly an independent contractor, focus on the word independence. A company that's dealing with an independent contractor should only be giving that contractor a description of the task that is to be performed and a deadline by which time they have to get it done. Other than that, the company should have no control over when the person performs the task, how the person performs the task, or where the person performs the task.
Or even who performs the task.
Right. Independent contractors generally do not work on the systems or computer systems or use the tools of the company that has engaged them. And they're in business for themselves. So they probably do this for more than one company, typically. If they have employees, they maintain their own insurances, general liability, workers' compensation, employment practices liability insurance, because remember, they're in business for themselves. However, if a company uses the services of an individual and that individual only works for this one company, and there's an expectation as to when the person's going to be in the office, and the performance of their duties is being supervised by either the owner or a manager within the company, you don't have an independent contractor, because that person lacks the independence. That person is supervised by somebody in the company. And once you have control over the when, where, how, and who that those duties are performed, that person is an employee and has to be treated as an employee.
So what's the ramifications if I misclassify someone? So if I call them an independent contractor when they should be an employee, what could happen? What could go wrong?
Okay, so let's start with the premise that if somebody could be classified properly as an independent contractor and you misclassify them as an employee, there are no ramifications.
Okay.
As long as you treat them as an employee and pay them correctly, there's nothing wrong with employing somebody who could be an independent contractor.
So before you answer the second part of that question, I just want to throw something in. Can someone be both an employee and an independent contractor to the same company?
Practically, no.
Okay.
No. So if somebody is classified, improperly classified as an independent contractor, but the company that's using that person's services is exercising control over when, how, where, who performs the services, then the person should be classified as an employee, and there can be consequences to improperly classifying the individual as an independent contractor.
Okay.
By misclassifying somebody, You can run into issues with the Internal Revenue Service because you're failing to withhold payroll taxes. You can have issues with the Department of Labor because that person is probably not submitting time records, time and attendance records. It's going to be very difficult to demonstrate that you're properly paying that person for the time that they're working for the company. There can be workers' compensation issues if the person gets hurt while performing those tasks. So there's a host of different responsibilities that a company can shirk by misclassifying somebody as an independent contractor. One of the things we like to do whenever somebody says, you know, I'm going to use this person as a contractor rather than an employee. All right, so let's talk about that. What do we look for when we're trying to determine whether or not someone can properly be classified as an independent contractor? What's the evidence that that individual is in business for themselves? Do they have an LLC or a corporation, corporate identity, or are they just working as an individual? Are they doing this work for several different clients? Or alternatively, are they just doing work for your company?
Okay.
Where do they typically perform their services? Do they have a home office? Do they have a outside office that they pay the rent on? Or are they typically coming to your office every day, using your computers every day, using your tools every day? All of those considerations should be taken into account in determining whether or not somebody is truly independent and whether they can properly be classified as an independent contractor.
Okay, I like the fact that you use the word considerations there, because I think you have to evaluate, as you said, each one of those. So just because someone's incorporated or has an LLC doesn't necessarily make them an independent contractor.
Right. It doesn't end the inquiry. There's no bright line get out of jail free card when it comes to classifications. And I mean that both between independent contractors and employees and between exempt and non-exempt employees.
Okay.
All of these are very fact-specific decisions, and unless you think you're at the very far end of being very conservative and being very comfortable that person really is in business for themselves,
Okay.
any gray area should be discussed with an employment attorney to make sure you're on safe ground.
So things like having their own website and doing advertising, business cards, all of those things help to kind of push things along the road.
I love to see websites. I love to see business cards. I love to see that the person has their own employees, has their own payroll account,
has their own workers' compensation insurance.
Yeah. If they wear a branded polo shirt, well, does it have your brand on it, or does it have their brand on it? These are the types of things that we look to feel more comfortable about the fact that the person's in business for themselves and not simply working for you under the cloak as an independent contractor.
One of the things that we also see, and just kind of making an observation before I ask the next question, but one of the things that we often see that organizations employ outside contractors, and the agreement they have with the outside contract doesn't say that they have to have workers' compensation coverage, and they don't even get copies of workers' compensation policies to prove that they have it, which becomes a problem, because if obviously the outside contractor doesn't have their own policy, workers' compensation rules are much broader than employment rules, so it's possible that the organization may have to cover them under workers' comp and could be liable if they get injured.
Yeah, it's just one example of that sort of gray area between independence and the employer-employee relationship.
Okay, we don't have a whole lot of time left. We got about 8 minutes left.
Sure.
So let's kind of switch gears a little bit. One of the things that we're seeing a lot of happening right now with is the Family Medical Leave Act and the New York State Paid Family Leave Act. With a lot of the mission critical staff and everything who are working for an organization, and now all of a sudden, one of these employees takes off because under one of these two rules, what should an organization do? What can an organization do with respect to that?
Okay, so let's start with the premise that Family Medical Leave Act only applies if a company has more than 50 employees within a 75-mile radius of each other. So when we're talking about small not-for-profits, we don't have the FMLA concern.
Okay.
Larger not-for-profits, you absolutely have that concern. So let's put the small guys to the side for just a minute and talk about the effect that the Family Medical Leave Act can have on not-for-profits. One of the things that we talk to employers and especially not-for-profits about is if somebody isn't there, can work still be done? If you have somebody who has to go out on family medical leave, can the organization continue to do the work that it's set up to do? Have you properly cross-trained employees to make sure that balls don't get dropped,
So this
so
is
to speak?
preventative sort of thing that organizations should be thinking about. Okay.
The other thing we talked to, and this has become one of the most recurring issues that we have with employers, both not-for-profit and otherwise. If you have an employee who suddenly is out for 2 weeks and they tell you, look, I have to have a procedure. I'm going to be in the hospital for a week. I need to be home for a week. And they make no mention of family medical leave, but it applies to your company. Don't wait for them to ask if they can take family medical leave. First, make sure that they are eligible, that they've worked a sufficient number of hours for the company to qualify for it. And if they are eligible, proactively send them the information about what their rights are under FMLA,
Okay.
what they have to do to exercise those rights under FMLA, and follow up with them. Because to a certain extent, FMLA is one of the rare employment laws that does also protect the employer. There's a 12-week maximum to FMLA leave. But you have to let the employee know that you're designating leave as FMLA leave.
Okay.
So if somebody's out they say they're going to be out for 2 weeks, and they end up being out for 3 months, okay? That's 12 weeks that they've been out for a legitimate medical issue that would have qualified for FMLA leave. But if the company never takes the steps to put that employee on notice as to what their rights are, how to exercise those rights, never gets healthcare professional certifications for that leave, it inhibits the company's ability to let the employee know, look, this time you're taking off, your job's protected, but,
For 12 weeks.
but we're capping this at 12 weeks before we have a different discussion about whether you're going to be able to work here going forward. You, under certain circumstances, can retroactively designate leave as family medical leave, but we caution employers to only do that in rare circumstances, and it has to be done in a way that doesn't hurt the employee. So if an employer comes to us and says, look, we have an employee who's been out for 12 weeks. We want to retroactively designate the full 12 weeks and tell them if they're not back here on Monday, then we're done. That application of FMLA hurts the employee and will be torn apart. So what we try and do is say, be proactive. Again, it's another issue. It's another instance of open communication being a really powerful tool for the employer, because when an employer knows what they expect of when an employer tells an employee what's expected of them, an employee talks to an employer about what they expect from the company, generally you avoid 95% of these problems.
Okay. In 60 seconds, what new regulations are you tracking that could impact the nonprofit sector?
Okay, so the 50 person threshold for the FMLA does not apply to paid family leave.
Okay.
So what we are seeing is a lot of companies that are having to absorb the soft cost of paid family leave. Employers don't have to make the payments for paid family leave, but they have to make sure that those jobs are protected and that employees are free to take paid family leave for the care of family members.
Okay.
So if you have a question about paid family leave, either how it's designated, how it's applied, when it can be taken, how it can be taken, give us a call and we'll have a conversation about that.
Okay. So if somebody wanted to give you a call, how would they go about reaching you?
Sure. So I guess the easiest way to start is with our website is SilvermanAcampora.com. We're located in Jericho, and our telephone number is 516-479-6300.
Awesome. That was great, David. I appreciate it.
I
Appreciate your time.
it too. Thanks a lot.
So thanks for tuning in and have a great Labor Day, everyone. But just remember that our next connection will be September 20th when our guest will be Ken Jones of Sterling Risk, and he'll be discussing risks and how to mitigate them through insurance. So thanks a lot for tuning in.
Thanks.